Zero Pettifoggery, sir. This is episode 11, February 23rd, and in a minute, February 24th, 2021. The long awaited 11th episode. Took a little time off. Was still producing some videos, so you'll see some updates and clips dating back to November. Cases in the appellate division, the state versus Andrews and the state versus Kearstan. Plus, I have a Marauding for Your Ears podcast recommendation of Verified Dust Up. Focuses on the discussion of Johnson & Johnson and talcum powder. Very interesting podcast, and I highly suggest you check it out. I was initially going to provide an update, which I had recorded in December 18th, regarding the legalization of marijuana in the state of New Jersey. And obviously with the latest news, that clip definitely needs to be updated. But I think what I'll do, because I did provide a decent amount of information in that clip, I'll most likely produce that clip and provide that clip to you guys from, I think it's late December, and then I'll give an update to legalization after I get an opportunity to read through some of the bills and read through what was signed into law by Governor Murphy yesterday. So exciting stuff, and thanks for tuning in. Hey everybody, November 18th, about 9 p.m. Got an update on a majority opinion by the Supreme Court in New Jersey, handed down in the state of New Jersey versus Andrews. Now, pretty interesting case off of most of the media covered in some of the headlines. For example, quote unquote law.com, why cell phone passwords, per divided NJ court are not contents of one's mind. Again, absolute total clickbait of a headline. Doesn't really help inform the reader, doesn't really help you make a decision whether or not you want to read the article. But yeah, it's this is the media, so this is what they do. They attempted to distill down a 47-page majority decision down into one quick headline. So case focuses in on passcodes to your cell phone, and the argument by the defense in this case was the police in this situation violated the defendant's rights to against self-incrimination when they forced him or required him to disclose his passcodes to his cell phone in order for the police to access his cell phones. Now, this case was, as you can tell in the headline, divided. There's a majority, what they call but a slim majority opinion. And what the majority essentially said was the rights against self-incrimination really focus on statements. They really focus on testimonial communication. They focus on outright conversation, dialogue, etc. Now, same reason why, you get people that come up to the stand who might be the getaway driver to a robbery. And the getaway driver, if asked particular questions about his role and hasn't pled guilty or hasn't really been admitted to taking part in that robbery, might say, I plead the fifth. I'm sure you remember Dave Chappelle. I plead the fifth. So pretty interesting because it's useful in a lot of respects, but we're in a very different time right now where a lot of things are on our cell phones. A lot of things are typed into our cell phones or even recorded audio clips that are sent through our cell phones. You can even be sending videos. So in this respect, the court essentially said, we're looking for, in order to invoke your rights against self-incrimination, we're looking for testimonial statements. We're looking for dialogue, conversation. We're looking for testimony. And what the court essentially analogized your cell phone to is more of a physical disclosure or a tangible disclosure. Um, Analogy being your home, your car, maybe a briefcase that you're carrying. And by doing that, they're essentially saying that these tangible or physical disclosures or discoveries are not covered by the rights against self incrimination. And um, God forgive me if I say essentially again and again and again, but I'm going to say it. So, when police officers or a prosecutor or a detective comes to you or in any circumstance and they provide to you a search warrant, generally the search warrant will indicate very specifically where you are allowed to search. Um, they will get down to the nitty gritty about where you are allowed to search. And in particular, what are you searching for? Now, if you're getting a search warrant to go to a home to an effectuate maybe, or getting an arrest warrant to effectuate an arrest, right? You're going to go to someone's home. You're not going to be able to look inside the nondescript cigar box sitting on somebody's shelf. Okay. People can't hide in cigar boxes. So um, that's where the search warrants get down to the nitty gritty. So very particular. That's where the court has kind of placed your cell phone passcodes. And that's why they're saying it's not against your rights of self-incrimination. And on the dissent side, the Association of Criminal Defense Lawyers came out and essentially said, we disagree with this. They said in particular, you know what, your privacy is constantly shrinking. The Constitution provides shelter against our innermost thoughts, the contents of our mind from the prying eyes of the government. No United States Supreme Court case presently requires otherwise. No court case has held otherwise. That protection deserves the utmost respect and should not be lessened to authorize the courts to compel a defendant to reveal the passcode to a smartphone. Now, I think on the dissent side, I think they're exaggerating to a large extent of what the contents of a cell phone may include. Now, I understand some of you might be blogging on your cell phone and you might be texting on your cell phone, which they can get to the cell phone provider. You might be having conversations on your cell phone, which obviously they can get not the contents, but they can get who you were talking to through your cell phone provider. But I'm not entirely sure where they're saying, hey, listen, my privacy is being violated. You're going to get your passcode to my cell phone and you're going to be able to access my IGTV where I can say, zero pettifoggery, sir. You can catch every episode right here. So kind of a swing and miss on the dissent side, but pretty interesting case. I know a lot of people will be thinking encryption might be the way to go. And going to the Chromebook quote unquote status of a cell phone, which a lot of people have been doing, and I know a lot of people talk about, in which the Chromebook serves as a very it's a shell of a laptop. It doesn't include a lot of storage, doesn't include you maintaining a lot of files, but it keeps those files completely separate on external hard drives. Here's my laptop. It's got basically nothing on it but applications that don't have a whole lot of contents to it. So pretty interesting case, and I'd appreciate any comments or questions or thoughts on it. I know it's a little thought-provoking, and I'd certainly be willing to talk about it. So I'll have some more soon. Thanks, guys. Hey guys, Monday, Cyber Monday, big time for you shoppers. Not so much for myself. I'm not much of a shopper myself. But November 30th, and coming to you with a quick update. Marauding for your ears. Marauding for your ears this week, and hopefully for the last month, is a podcast by the name of Verified Dust Up. Okay? Podcast is looking into the tainted history of Johnson's baby powder. And its links to ovarian cancer and obviously having asbestos in its products. Makes for a very interesting listen. produced by a production company by the name of Witness Docs that usually do some pretty quality podcasts. So check it out. You'll also notice I'm hanging out in front of my new Peloton. I am 10 days in, and naturally, I guess this is the fever and the honeymoon phases in, 10 workouts in. So catch me on the Peloton as well, at Mr. Duraney. All right. Have some more coming for you soon. Hey, how's everybody doing? November 16th, 2020, about 10 p.m. Quick update coming from the appellate division in an unreported case, the state versus Kearstan. Now, one of the things you might notice, I said unreported. If you were to dive into the areas of law and case law and common law of reported decisions and unreported decisions, you'd find a whole rabbit hole of, does this apply to me? Will this have forever lasting consequences? Maybe it won't, maybe it will. If that's something that concerns you, I'd certainly encourage you to read up on it. Pretty interesting stuff, but bottom line is not every case is slated to provide precedent. Most often that is done because the facts are way too case specific. So it sounds like that's the case in this one. Defendant arrives at his marital home with damage to his car and a missing mirror. This is on appeal of a DWI conviction. His wife calls 911, reported he's in the basement and has an alcohol issue and is intoxicated. An officer goes to the house to conduct a welfare check. The wife invites the officer into the home, and the officer sees the defendant staggering with difficulty trying to pull his pants up. The officer noted the defendant needed assistance to stand up, and the officer invited the defendant outside to talk away from his children. When they got outside, the officer noticed the defendant's bloodshot eyes and slurred speech. The defendant then admitted to have several drinks. Another side note. Whether or not I will seem like a standard criminal defense attorney, whether or not you might not like this advice, bottom line, do not speak to police officers, okay? Not because they're bad people, not because they are terrible judges of character and that, they really are out of control and they're really going to put words in your mouth. Just do not speak to police officers in a lot of circumstances. For some people, that's a lot of controversial advice. But for me, I always take that and I provide that advice in the context of criminal law. I am a criminal defense attorney, and far too often do I end up in circumstances where my clients have spoken to the police officers, and then they turn around to me and they say, what can you do to help me get out of this case or get off these charges or reduce these charges? And it's, okay, well, you've already made your bed. So I'm not saying do this to make their job more difficult, but I'm also saying, be smart. And part of that is generally not saying anything to police officers in circumstances like this. So, not COVID, I promise. So, officers administer field sobriety tests when they're outside. A blood draw shows a blood alcohol content of 0.29. So the defendant moves to suppress the BAC test and his incriminating statements. The trial court denied the suppression motion, finding the wife invited the officer into the home, yes, but the warrantless entry was justified under a community caretaker and emergency aid doctrine. Remember, the wife called the officers 911 to come to her home to check on her husband who was drunk, smelled of alcohol, and not handling himself very well. So, and the questioning, they said, was similar to a preliminary roadside drunk driving investigation. The defendant argued that removing him from his home was improper and his inculpatory statements were obtained in violation of the Fourth Amendment. The appellate court agreed with the trial court that the officer lawfully entered the home at the wife's invitation, and the defendant's incriminating responses were the result of a proper investigatory interrogation. So, pretty interesting case. Couple lessons here. Number one, if you have a good relationship with your wife, she won't call the police on you. Number two, don't say anything to police. Number three, most importantly, don't put yourself in danger. Don't put others in danger. don't drink and drive. Got some more coming after you next. Thanks.